Hi everybody, it's attorney Brooke Goff, coming to you from our little studio within our Hartford office. I am bringing to you today slip and falls. I'm doing so because that was voted in our poll. I posted a poll, I don't know what it was, this weekend, last week, whatever. And I said, what do you guys want to hear more about? Slip and falls or workers' comp? Slip and fall got the vote. So let's chat, right? Slip and falls. People get embarrassed, right? And they sometimes choose, okay, well, I'm not going to do anything because I'm so embarrassed that I'm just going to try to get up and I'm going to try to walk it off. Don't do that. Well, if you can, fine, but don't do that. So if you fall, I don't care if it's in public, I don't care if it's on a sidewalk, I don't care if it's in a grocery store, I don't care if it's in somebody's house, yard, what have you. Firstly, remain calm and see if you're really injured. What does really injured mean? I mean, like immediate medical attention injured. Bleeding? Did you hit your head? Did you, is there a possibility of concussion, confusion, loss of consciousness, these types of things? Broken bone? Is there a bone that's where probably where it doesn't belong? That kind of a thing. If you're okay, you need to notify management. What do I mean? I mean property management. I mean the owner of the property, or I mean if you're in a grocery store, the manager and or owner, if they're there, of a grocery store. You need to notify the owner, the person in charge, and you need to get a written incident report. Do not leave until you get that incident report. Why? Because when you leave, right, when you get up, I should say, they're going to wipe up the spill, they're going to clean up the mess, whatever caused you to fall. Any evidence, of course, they're probably going to clean up. They don't want anybody else to fall on it. There's your evidence, okay, guys? So you definitely want to make sure that that incident report is correct, accurate, and do not leave without your signed copy. Take photos. Now, I'm not saying don't be ridiculous and make sure you're on the floor still so you take photos. Don't do that. I also, please, so many people take photos of them on a stretcher and all this other stuff. Don't do that either. Why? Because it makes it look like you're doing it for litigation. Okay, you don't want to do that. So what am I talking about? Pictures. Take pictures of where you fell. What's around you? Take pictures like if you have like a set of keys, put the keys down and take the pictures there. Take pictures so that we know where you fell. So when we get investigators to go in there, we tell them where the area where you fell. Also, look around. Are there cameras, right? Are there any cameras around? If there are, we're going to want to know that. Make sure you note that. Snap a picture if you want. Why? There's no rule against it. And because if there are pictures, we're going to want to know, cameras, we're going to want to know so we can get something called, we file a form called the spoliation of evidence letter, and that requires them to turn over to not destroy the video that exists at the time, right? And we usually get that down the road at litigation, but if it's on video, guys, they're going to tape over it 90 days if you don't get the spoliation of evidence letter out, all right? So, and let me tell you, so many times, I get where people are like, oh, well, I can go back and take pictures. Take them then, all right? If you're not severely injured to the point where you need immediate medical care, take the pictures then. And also, if there's no warning markers or cones, make sure that the pictures you take don't show any, right? So you don't want to take pictures after the manager runs over with their cones or the warning markers or whatever it is. You don't want to do that, all right, guys? So make sure that you take the pictures when you're on the ground there if you can, or get up, move out of the way, and take the pictures if it's safe. Are there any witnesses? Are there anybody that see it happen? Get their name and their phone number. Ma'am, could I just have your name and phone number? Or sir, can I have your name and phone number? Make sure the manager knows who these witnesses are so they know in the report there was a witness. That all comes in handy. Won't come in handy now. It's going to come in handy, a year later when we're in litigation over the issue. All right. If you have pain anywhere, don't be a tough guy. Take the ambulance to the hospital. They're going to offer to call you an ambulance. Well, they should. And if they don't, then you can do it on your cell phone or a witness will do it. Take the ambulance to the hospital. Who cares about the bills, guys, all right? Most insurance policies for facilities, whether it be a grocery store, whether it be a home, they have what's something called MedPay. What's MedPay? Medical payment coverage, right, is something under insurance that will pay the first X amount of dollars of medical bills incurred by an injured person on the property. So, for instance, most household insurance policies have a $5,000 or $3,000 MedPay coverage, right? They do, just the way it is. Grocery stores, I've seen them up to $10,000. So, if you have no insurance, right, and you fell and you're injured, trust me, the last thing you want to do is leave, go home, and then not report it, not take photos, and then find out you're really hurt and have to report it months later. I've had this happen, guys. It is a hurdle to get over. And let me tell you, it affects case value by 50% or more. Okay? So in this situation, if you are injured and even if it's not immediate, if you're injured, if you feel anything, you need to report it to the manager. You need to call an ambulance, go to the hospital. Let the doctors do the doctor's jobs, right? Just like you let the lawyers do the lawyer's jobs. And whatever you do for a living, you do your job, right? So let everybody do their job. Let us worry about the medical bills and how they're going to get paid and everything else later on with the case, right? And clearly, if you're not injured, you're not going to do any of these things, right? You're going to be okay. You can still take pictures in case you're injured and all these other things, but we're not so worried about you taking an ambulance. If you don't need an ambulance, I mean, don't be a tough guy, but if you don't need an ambulance, you don't need one. I'm not trying to push that. What I'm pushing is if you feel any kind of pain, discomfort, sometimes adrenaline can make the pain not feel what it is, and then hours later, you're like, holy cow, I'm in a lot of pain. Try to actually make a very educated, okay? Very important. Make an educated decision of whether you should take medical care at that time. All right. If you have visible injuries, document them with a photo. All right. So what does that mean? Now, here's the thing you have to understand. I'm not saying document them when they appear. Every day, if you have bruises or if you have stitches or whatever you needed, take the timeline pictures with your phone. It takes 5 seconds, right? It's like taking a selfie. Take the photos. Don't post them on Facebook, guys, okay? Please don't post a picture of you on the stretcher. Don't post any of that in social media. Insurance companies have gotten so smart. I was just having this conversation today. The first thing the insurance company does is, you know what they do? They totally troll your Instagram, your Facebook, not Snapchat. There's this new one. It's a photograph one. It wasn't around when I was growing up, but your Twitter, all these things, they're going to troll it. All right, they do. And they're going to troll your friends too. So don't post pictures of you in a stretcher. Don't talk about, oh, I'm going to get a payday or any of this stuff. It sounds like stupid, but I'm telling you because it's from experience. Don't post it, okay? Don't post it. And I need to make sure that you understand that. You're going to want to make sure that you always plan for the future, okay? So always think, okay, well, how could this be interpreted? Think of it as if you're a juror. If I was a juror on this case and I saw a picture of the client or the injured person on a stretcher taking selfie, and then they posted this post on Facebook, how are you going to do it? And with guys, slip and fall cases, you're already on an uphill battle. We don't need any more issues, right? The other thing, too, is, don't just give willy-nilly statements. Slip and falls, you need a lawyer. Done. Okay? Done. That's it. Slip and falls, you need a lawyer. You can talk to any lawyers who are going to tell you the same thing. It's not like a motor vehicle case, and I'm telling you should have a motor vehicle attorney as well. But every slip and fall case is almost everyone that comes in my office with significant value gets litigated, meaning it goes into suit. You're not going to do that on your own, right? You're just not. And trust me, my fee becomes irrelevant. So get a lawyer in the beginning. There's notice requirements for certain things. I can't tell you how many cases I turn down a month. Attorney Goff, I heard you on the radio or I heard you on your Facebook segments or whatever the case might be. I say, thank you for listening. And they said, well, I broke my leg. I fell on ice in, let's just say, the town of I'm making this up, guys, town of Hamden or something. And guess what? I broke my leg and I didn't do it. It's 2 years, right? It's 2 years. It happened a year ago. Can I do something? Did you put the city on notice under the statute 13A149? And they say, what is that? Well, there's a notice requirement. Find out they didn't do it. Guys, if you don't put the city on notice or the town on notice within 90 days of your fall, you're SOL. The 2 years, so you have to actually put them on notice within 90 days. Then on top of it, you have to sue them within 2 years. If you don't have a stamped notice that says your name, date of incident, time of incident, location of the incident, how it happened, literally where it happened, measurements are good from like a telephone pole or what have you, your injuries, this type of thing, you're not, and it's not stamped by a town clerk or city clerk, you're done. You have no case. 90 days. They don't give you any time, right? The state has similar rules as well. So, and for the state, in order to be able to sue the state, you actually have to get permission from the state. It's a process called the claims commission. You literally have to trial your case twice. City cases, there's also a rule with the 1% rule, right? So that's what we call it. So you, in a regular personal injury case, slip and fall, not on municipal property, right? Sorry, I can't talk. It's a little late. What ends up happening is that you actually have not municipal. You have to only prove that you were less than 50% negligent. All right. So basically, if you were 49% negligent, you can still bring a claim, right? So basically, it's preponderance of evidence standard. That's what it is.
With cities and municipalities, it can't even be 1% at fault. If you're 1% at fault, you lose. Guys, every slip and fall, there's one thing you could have done, unless it's so gross and catastrophic. There's usually one thing you could always do to make up that 1%. So we don't try these cases. We like to settle these cases in court, and we do. The higher the damages, the better, of course. But if you miss that notice requirement, you're done. Okay? Done. State, again, must also be put on notice under their own statutes as well. And if you miss their statute, you're done as well. And you also have to get permission from the claims commissioner, like I said. You can't actually file a case against the state until you actually get permission from the claims commission. So let me give you an example. John, and there's notice, and I'm going to talk to you about this in a minute too. So let's just say you're in a grocery store, right? And it's raining outside. But guess what? It just started raining 5 minutes ago. 5 minutes ago. And you're walking in the front door, and obviously everyone's tracking water in, and you slip and fall 5 minutes after it starts raining on the floor, and you break your arm. There needs to be weather experts. This is why the photos are key, guys, right? And everything else is because guess what? The grocery store is going to claim we didn't have notice. We didn't have a reasonable time to cure the defect, the water on the floor, right? And that's a big point, guys, because notice comes in key. Homeowners, if you slip and fall on snow or ice on the property, and let's just say it's in the middle of a snowstorm, right? They're going to fight tooth and nail. Now, you're going to get a settlement, but you're not going to get as big of a settlement for a broken arm as what it would be worth, okay? There's this notice issue with slip and falls that always come into play. And let me tell you, attorneys don't like to do these cases. I actually love them. We have very good outcomes on them. But many attorneys prefer them out because they don't like to do them because they're difficult and they're different, and slip and falls are a whole nother animal. You have no business as an individual handling your own slip and fall. Trust me when I tell you. And the other thing, and we always run into this too, is I sit down and I talk to you, right? It doesn't hurt to talk to me about it. This is going to be a shorter segment actually because slip and falls, they're not, motor vehicle, boom, 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 boom. But, sit down and talk to me. If let's just say, I don't know, you fell on your neighbor's property and you're worried about your neighbor hating you or whatever. We deal with this all the time. We work with the neighbor. We'll talk to the neighbor. We'll deal with it. And at the end of the day, if the neighbor had no insurance, you're not going to collect anyways. But if we can get your claim in through their insurance and they don't drop them and or raise their rate, which they're going to get their rate risen anyways because of the issue, regardless if you decide to bring a claim or not, just for the fact that when they find out about it, because they need to declare it every year, it doesn't really make that big of a difference. Usually we can walk through and talk these things through with the homeowners and they're fine with it. Neighbors are like, I just want Johnny to be okay. Or, and if there's no deductible associated with it, usually they're a big fan of that. They're like, I don't care what you do, whatever needs to get him taken care of. But you have to be above board. When people try to do these things on their own, or okay, I'll call the insurance and I'll talk to them. Guys, they're never going to pay you anything where you're near. I promise you, these cases are not valued up. To be honest, I have not met one client that's come in here that's had their own offer from a slip and fall case before getting involved. Why? Because they don't offer. They deny. And then now, these cases, it's not easy finding a lawyer. We do them, but many attorneys, like I said, don't. But the problem with some of these cases, right, is that we don't get the facts until closer to the 2-year point. The investigation, everything's done. We need camera footage, right? If there's cameras, we want to get that. You need to get somebody early. If there's, if there's investigators, there's an investigation, we can do witnesses. You want to get all this stuff early, guys. It's not going to help you to hire a lawyer a year later. All right. So listen, I always give you guys good advice, right? And I always tell you guys what to do to protect yourself. And I always give you alternatives because I want you to hire me or a lawyer because as I say to my clients, I want you to hire me because you want me, not because you need me, right? That's key. If you can say that as a lawyer, your clients are doing that, you're doing it right, all right? In this particular case, you need a lawyer. Now, I hope that you want me to be your lawyer, but you need a lawyer, all right? Slip and falls. If you fall in a municipality, guys, 90 days. There is no ifs, ands, or buts. Incapacity, like if you're incapacitated, if you hit your head and had a concussion, was in the hospital for 90 days, yes, we could probably get that extended out, but not likely. It's not happening. If you miss that 90 days for your municipality, don't even play.
Here's the other thing you have to understand too. There's some ordinances with towns where the homeowners are responsible to cure the snow and the ice, right? So you still want to notice the cities in those cases in the towns, but you are likely going to have to go against the homeowner, which is awesome because at least the homeowner has private insurance and you're not dealing with that 1% rule, right? So you want to make sure that you understand that if it's against the city or town, firstly, you need to do a survey to see if it's city or town property. Sometimes there's like walkthroughs and some people assume this is city or town property. It's not. Let's say it's private property, or they assume it's private property. It's not city or town property and you blow your statute, all right? I've heard horror stories about attorneys blowing statutes because they don't know what they're doing when they do in this case. And they'll say to the client, well, it's a slip and fall against the city anyways. Who cares? Like, you know, as attorneys, we have a job to make sure that these cases are preserved and they're taken care of and they're brought from beginning to end, all right? Lastly for you, I'm going to leave you with this. Slip and fall, again, your biggest weapon in a slip and fall case is your phone, all right? And I promise you that it's your phone. Take a picture of where you fell. Take a picture of, if there's security cameras, snap a picture of the security camera. So if they claim that, hey, look, we didn't have a camera there. Yes, you do. Here's the picture. Take a picture of the area so that we can make sure that there was no, warning or anything else. So when they come running with the warning cones, you can say they weren't there. Because trust me, 2 years later, they're going to claim they were. Take a picture if when you're leaving, if it says, manager, permittee, whatever the case might be, snap a picture of that. There's your evidence. If they can't give you a signed incident report, snap a picture of the incident report. All right? Snap a picture of everything. Don't be weird about it, but snap a picture of anything except you in a stretcher, or you in a hospital bed. Why? Because you don't want that. It's not going to help your case realistically. We all know you went to the hospital. What you look like in a hospital, that's irrelevant. It's going to make a jury assume, and I have to turn these over, it's going to make a jury think that you had a lawsuit on your mind the whole time, and you don't want to do that. Second, the last thing I can leave you with is the most, again, weapon is the key word, is your phone, is social media. Don't post stuff on social media. Guys, I promise you, every single case, the insurance company trolls. They actually have companies that they pay privately. They troll your Facebook, Twitter, LinkedIn, whatever. If you're claiming injury, you know how sometimes we share memories, right? Well, guess what? They don't see it like that because it goes through a system. So they'll be like, oh, I have Jane over here doing like cartwheels and doing a CrossFit Tough Mudding thing. But guess what? That was 2 years ago. They don't care. Now you just create a huge hurdle you have to get over, and it's just not worth it. Don't post about your case on social media. The only thing you should be doing on social media is watching my videos and calling me afterwards, okay? So here's the deal. You can reach me on the office line. We're 24/7, even holidays. Got a few calls on Thanksgiving this year, and we anticipate we'll probably get more calls on Christmas, right? Because a lot of attorneys are closed. We're 24/7. You get a lawyer, and it's not a lawyer in India. It's a lawyer in Connecticut in our office that works with us. Phone number, 203-399-0000, extension 1. New cases, okay? Existing cases, always, as you know, you can reach us, 203-399-0000, extension 2. Email, Brooke, BROOKE, @gofflawgroup.net. Social media, here, you found us. So here we go. Add us, follow us, like us. We put these videos up all the time. Lastly, you can text us, guys. Everybody texts 203-399-0000. So easy number to remember. Lastly, have a Merry Christmas. And a Happy Holiday, I should say. I'm sure I will be on here one more time to talk about driving because we've been getting lots of crappy weather and or comp. I'm waiting for the next poll to come in. But I wanted to give you guys the information that you want. So always feel free to email me or ask me, say, Brooke, I want you to talk about dog bites. I want you to talk about, car accidents. I want you to talk about slip and falls. I want you to talk about car accidents. I want you to talk about workers' comp. And make sure, if you want me to cover a specific subject within a subject, let me know. Or if you just have questions you want to ask me privately, let me know too. No pressure ever. I'm very approachable. I'm not this big scary lawyer, and I'm reachable and I'm available, which I think goes a long way in this business. Again, call me if you need anything. You hear this video, it hits a note in your mind, or if this happened to you, talk to me or talk to another lawyer. Of course, I'm always going to say talk to me. I think I'm one of the better slip and fall attorneys in Connecticut. However, you can be the judge. 203-399-0000. Extension 1. Have a great day, guys. Have a great night, I should say. And brave the weather, because I guess we have another storm coming next week. Thanks. Have a good one.